right, now in the second half, I'm going to take up putting your case together, putting it together in the final plan. As I lay this one on you, let's think for a moment, where do you live and why do you live there? What do you do for a living and why are you working where you work? If you're like most people, it's accidental. You work where you are accidentally, you live where you're living accidentally. You haven't chosen your occupation. You haven't chosen the locality that you live in. Maybe you were born in Idaho and you stayed in Idaho all your life. Why don't you try Texas? Why don't you try Indiana? Is there something wrong with Florida? Now, the reason that I bring that subject up is when I go into the courtroom, I go in there with a predetermined and premeditated plan. I very seldom ever go out on the street and get a ticket unless I want a ticket. When I take the license plates off of my car, it isn't an accident. It's deliberate. I don't get tickets for running through stop signs or for speeding. I don't get arrested for things that I don't want to get arrested for. In other words, I want to test a particular law. I want to take an issue into court. Well, it can't be any different for you when you go into the courtroom. You cannot go into the courtroom accidentally and expect to win. It isn't something that you do on the spur of the moment. Most people that I deal with walk in the door, as I've said before, and say, hey, I'm going to trial on drunk driving in about 3 weeks. And somebody, a friend of mine, told me that you could help me win that case. Well, you know, that's like taking a soldier out and putting him in the battlefield, and he doesn't know how to use a bayonet. He doesn't know how to load the gun that he's got. He doesn't know how to shoot it. He couldn't hit anything if he did pull the trigger and it went off. And so he's really a pretty poor candidate to be a soldier. And if you're going to be a soldier in this fight, then you ought to be, in my opinion, before you get into the big fights, you should be a battle-hardened veteran. And, you know, instead of sending a guy up to the cliffs on D-Day, you know, with grappling hooks, and he can't even climb up a rope, which is what some of those fellows had to do over in France, you know, on D-Day. Don't you think that a guy ought to be out here practicing where he's not being shot at and where he's, you know, strengthening his arms as he's climbing up ropes before he attempts to attack the enemy? Well, you know, what I see is people going into court every day with no battle plan. They don't know why they're there. They know that they don't like the master, the government that they have, and so they want to look at George Gordon and they say, well, you're a good master, and they want me to represent them, or they want someone else to go in and fight their battle, and they'll come in and they'll say, I'll pay you so much if you'll do this for me. Okay? Well, this is a fight, when you're talking about rights, this is a fight that only you can argue. Remember, the belligerent claimant in person, you know, has to claim his rights personally. It isn't something that I can do for you. I can do it for me, you can do it for you, but you're the only person that can do it for you. So when I go into the courtroom, I take a yellow pad and I have several pages in my battle plan. I don't care whether it's a parking ticket or whether it's a felony. When I'm going in there, when I'm going into battle, so to speak, when I'm walking into that courtroom, that's a fight and that's a battle. I'm there to win, and I'm there to train myself and to be as well prepared as I can be. A soldier going into battle, I've never been in the military, but I would suspect, you know, that he'd check his hard hat and make sure that it's got a chin strap on it so that it doesn't fall off. He's got, yeah, I've got 500 rounds of ammunition, and yeah, here's my gun. Yep, it's cocked and loaded and ready to go, and the bayonet's already on the end of it. And let's see, have I got my pack on? And that's exactly what I do. And I start 3 weeks prior to trial. 3 weeks before the trial, you should sit down and start going over your battle plan. The first thing that I do is I check out the time, date, and place. You know, I have actually gone into the wrong courthouse. Yeah, that's right. It's embarrassing as all get out. You know, you get there and it's 9 o'clock and it's Wednesday and you're ready to go to trial, and oops, you forgot to read. Oh, it's at the courthouse downtown. It's not out at the traffic court. You know, you need to sit there and run over your checklist. 1, date, time, and place, call the clerk of the court and say, "This is George Gordon, and I just want to confirm, does your calendar show that we're ready for jury trial on the 14th of June? And she'll say, "Yes, that's what my calendar shows." I've had them say, "No, I'm not showing a jury trial, Mr. Gordon. I'm showing a court trial." Wrong, woman. Now you go into your file and you say, "Did I motion up a jury trial? Did I somehow make an error?" Okay? Now, if I've got a motion in my file that says motion and demand for a jury trial, typically when you file your jury motions, it'll say a jury trial of 12, not 6, but of 12, and you've made your jury demands to try the law as well as the facts. Now, if you walk in there and you're ready for a jury trial and you've motioned up a jury trial and done so timely and they're not prepared with the jury, that's their problem in life. And I'm not going to sit here and tell them. I just want to ask the question. Okay? There's one item. Now you've got the date, the time, and the place set. Now, maybe this is 3 weeks before trial. When's your last motion hearing coming up? Is it 1 week, 2 weeks, 3 weeks before trial? Maybe you've already had your last motion hearing. Do you need to file any more motions? If you'll go through your file, you'll find, oh, darn, I don't have my motion in on jurisdiction. I don't have this brief in. I don't have that affidavit. You run through each and every one of them. Do you have every motion, every brief, every affidavit that you want in this case filed with that court 3 weeks before trial? Maybe you don't have time to file it, motion it up, and argue it orally, but you still need to get it in because it's an appealable issue and it must be in prior to going forward at trial. All right? Now, you're satisfied that your file folder is 100% complete. You're satisfied now you got the date, time, and place set. All right. Now, how many witnesses are you going to call? Are you going to wait until 3 days before trial and then get on the telephone and say, "Hey, Barney, have you got time to make it to trial? Oh, Sam, could you come over? I might need you as a witness." Isn't that the way most people deal? I would subpoena my own mother into that case. I'll file a subpoena on everybody I want there. You know why? There's a psychological advantage. You know, you can tell your friend or your mother or your dad or whoever's going to testify what the date, time, and place is. And do you know what will always happen? A day before some emergency comes up, and darn, could you do without me, George? Gee, I just can't make it. And then you're really hard put, you know, to say, "Hey, man, I need you there, and I need you there on the 14th of June at 9 a.m. All right, so what you do is you write up the list of witnesses. Now, typically, at the early beginnings, I'm that loud, belligerent claimant in person, and I'm making statements and demands of people and taking their names down. Because, you know, 4 months later, it's impossible for you to remember. "Oh, yeah, I was in the jail. What was that guy's name? Oh, gee, I'd really use him. Boy, I'd really be able to ask him some nifty questions, and I can't remember who he is." So you go into your file folder and you pull out your yellow page, and here's all of these notes. It was Sergeant Smedley, and Jill Jones, and Charlie Smith. Oh, and my dad was riding in the car. Oh, and my wife was there, and my teenage boy was there. Oh, and then there was this other guy. Remember that guy that was just walking by on the sidewalk, and I said, "Hey, mister, come here." And he came over, and I got his name and address. And you'll find, if you do this right from the scene of the crime, you'll be amazed. You could have 20, 25 witnesses. And remember, the objective at trial isn't necessarily to win, although that's kind of nifty. The objective at trial is to make it cost your government so much money that they don't want to see you again. And a 2-day trial costs twice as much as a 1-day trial. And a 1-day trial is twice as expensive as a half-day trial. And if you'll do your homework in here, that trial can last 2 or 3 days. I did a trial one time that was scheduled for a day, and the judge said, "Oh, I know Gordon's long-winded. I'm going to schedule it for 2 days." And when we got in there, it ran 3. Now, that's the way you want to prepare this. Not accidentally, but deliberately. From the scene of the crime, the jailhouse scene, the motion hearings, every stage of the proceedings. You want every witness you can get. The only reason that I only call 18 witnesses is because I don't have 36. If I had 36, I'd call 36. And the only reason that I dispense of a witness with 1 hour's worth of questions is because I don't have 6 hours worth of questions for him. If I had 6 hours worth of questions, we'd be there for 6 hours. Because 6 hours worth of the court's time, when they're talking about some kind of a Mickey Mouse ticket over here that they want a $40 fine out of, can cost them thousands. And that's where you want to be on every criminal prosecution. Any case that's important enough for your government to prosecute is important enough for you to defend. And if your government can spend $100,000 to put some criminal in jail in a 30-day trial, you, the tax-paying citizen out there, have a right to your redress of grievance in the court if it takes a week. All right, so now, you run down your list of your list of witnesses. All right? It may be 2 witnesses or it may be 20. Now, in Idaho, you're entitled to 5 or 6 witnesses to be subpoenaed and paid for by the state. Okay, and that comes under the 6th Amendment. Is it 5? My man here tells me it's 5. If you need over 5, you have to file a motion with the court and motion up the other 18. Okay, now here's a subpoena. Okay, now remember we went over subpoenas before, and it isn't necessarily to show this on the screen, but here is a subpoena. All right? The state of Idaho to Robert Hallstrom. You need your subpoenas written up, and you'll need 3 of them. So you go down to your local, this particular one here comes from a printing company in Pocatello. So there are printing companies that have these. They're already made up. They're already in forms. All you need to do is fill in the blanks. Your first time out shouldn't be a felony when you're going into the district court. Your first time out should be a ticket somewhere, so that when you make these errors and mistakes, which you're inevitably going to do, you're going to forget to file some subpoenas, or you're going to forget some motions, or you're going to forget the date, time, and place, or, there's mistakes you're going to make. Take your subpoenas and fill out 3 copies of them. Take them down to your local court clerk, and if there's 5 of them, you're safe. If there's 10 or 15 or 20 of them, then file a motion with the court, and you need an affidavit, and you have to list Robert Hallstrom, his address, and what is it that he's going to testify to. Now, it's all right to bring 2 or 3 witnesses in to testify to a particular fact. If 20 people were present, and they saw a particular fact, that doesn't give you leave to subpoena all 20 of them in to testify to the same fact, circumstances, or events. That's just superfluous testimony and just wastes the court's time. So rather than have the court call you down on that subject, don't subpoena in more than 3. So what I do is, let's say that you've got 6 events. 18 people saw them. 3 people for each event. One witness may have saw all 6 events, and he can testify to all 6 of them. 1 or 2, maybe they only saw one particular event, just in the jailhouse. That's all they saw. That's all they know. You can bring them in, ask them 6 questions, and they're out. Okay? Now, in that case, you file it up. It's under Title 19 here in Idaho. You'll have to take a look at your own state statutes to find out what the rules are in your state. But don't overlook this, because if you walk into court there with 20 witnesses and you fail to follow the rule, they can exclude all but the 5 witnesses that the statute calls for. So you must motion that up. So you put that on your checklist now. All right, now you take all of these subpoenas over to the judge, and the judge will look at them. And when he looks at them and he excludes key witnesses that you absolutely need, you motion it up for oral argument. You say, this man is absolutely necessary and imperative. You create the record. And this is why you need to do this about 3 weeks ahead of trial. If you wait until 3 days before trial, remembering that subpoenas have to be served a minimum of 24 hours prior to trial, prior to that opening bell at 9 a.m., so you'd have to have it served by 9 a.m. the previous day, you'll run out of time. You'll go to the judge and you'll run out of time, and you've had plenty of time, and you won't be able to argue that, and you'll lose these witnesses. And these witnesses are extremely important in this trial, both to you for winning in front of the jury, but also as a matter of judicial economy. You have a right to them. And remember, you want that trial to run 1, 2, maybe 3 days. And if it's going to run 3 days, you need your 18 witnesses. But don't overdo it. In other words, I see excesses a lot of the time, so I want to caution you. When you come in with 36 witnesses, you know, they're saying 36 witnesses to a speeding ticket. Boy, they're going to really try to edit that. And I'd say, yeah, that's probably true. I doubt seriously that you could justify 36 witnesses for a speeding ticket, but you could probably justify 5 or 6. Now, if it's a speeding ticket and driver's license and registration and obstructing and delaying and resisting arrest, and, you know, you've got 5 or 6 tickets here that you're going in to argue, it's not uncommon to have 3 or 4 witnesses on each one of those issues. You might even want some expert witnesses. You got a radar ticket, you want to bring in 2 radar witnesses. And then I've noticed here in Boise as an example, there doesn't seem to be any shortage of experts who have been in the Air Force and the Army and that have worked on radars and even built them, and they've 25 years experience, one of our students had here, designing and building them. In fact, he was so knowledgeable about radar, he couldn't even talk about some of the things that he knew about because they're still classified and secret. He's been out of the Air Force for several years. So there are a lot of people that know things about radar, and what you do is, under the rules, you call him up as an expert witness. Now, this thing of witnesses, you know, is extremely broad and extremely important. So here you are, 3 weeks ahead of trial, and you come out with 18 witnesses, and you want to qualify each and every one of those. You've got a right to 2 or 3 expert witnesses. Every witness that has a material fact, 2 or 3, that saw every material fact that he's going to testify as to what he knows, what he saw, and what he heard at the scene of the crime, at the jailhouse, or what he knows about the law. You know, a lawyer, if you have a lawyer friend or you have someone trained in the law, he can be an expert witness in law. All right? So there's your subpoenas. Now, there's another item off of your checklist then. Your subpoenas are lined up, got them all stacked up. You don't need to serve them until, 3 or 4 days prior to trial. If you've got any idea that some of these people may be out of town or something like that, you want to serve them in plenty of time so that they don't have an excuse, you know, not to show up. Now, always serve subpoenas on your close friends, and you do that 2 or 3 weeks ahead of time. And the reason is, hey, Sam, here's your subpoena. I need you at trial now on the 15th of June. You'll be there, right, Sam? Oh, yeah, that's right, George. Gee, glad you reminded me. Now, it's really rude of your friend Sam if he comes up to you 3 days ahead of trial, you see, and says, hey, I can't make it. What happens is when someone comes to him and says, hey, let's go hunting on the 15th of June, he says, oh, gee, I'd like to do that, but I've got to be in court. You know, I'm subpoenaed in. But a week or 10 days ahead of the trial, somebody says, hey, let's go hunting on the 15th. He isn't thinking about the trial. He says, yeah, let's go hunting. And then all of a sudden, you give it to him 3 days ahead of the trial, and he says, hey, man, could you do without me? You mean you've got 18, what's 1 less? And then, well, you've got 17, what's 1 left? And pretty soon you walk into court, and you're lucky if you got 3 or 4 witnesses. So these subpoenas are crucial to your trial and to your position. And you're trying to send a strong message to your government and to your courts and to your prosecutors. Don't mess with me because I'm very expensive. All right, so there's your subpoenas. Now, how many of these witnesses are going to testify? All right? All of the witnesses are going to testify as to what they saw or heard, except the expert witnesses. Maybe you don't know what they're going to testify to, so what you do is you get 18 pages for your 18 witnesses, and you write the fellow's name right at the top of the page. Sam Smedley, expert radar. Okay? Now you should call Sam and go to lunch with him or sit down and say, Sam, what are some of the questions that I should ask you? Well, you should ask me about Doppler and 1, 2, 3, and maybe you'll come up with 30 or 40 questions for Sam. Just like you do on the jury voir dire, which is I'm going to cover in the next item here. You go over 40 or 50 questions, and you'll be amazed at how long you're going to be in court if you'll do this and plan for it. And how short the trial will last if you don't write the questions down. And I mean you're going to write every question down that you can think of that Sam knew about, saw, or knows about. Now, if he's an expert witness, he wasn't at the scene, he doesn't know anything about it, but he's going to testify as to the expert things. He'll probably hand you a little book and say, yeah, man, look at this book here, and just take a look at this. They went through here at the Boise School, the radar book, and somebody wrote up 154 questions. I think it was 154 questions on radar. I couldn't right now, off the top of my head, think of 5 things to ask somebody about radar. That's how ignorant I am about it. But if I had a radar ticket, let me tell you, I'd have my yellow pages out here and my witnesses. And here's all the questions. And you'll be amazed, too. When you start asking these questions, he'll give an answer, and that answer will generate 2 or 3 questions. And so it isn't inconceivable to have an expert witness on the stand for 5 or 6 hours. And if you've got 2 of them, that's a day shot right there, just talking to expert witnesses, not even getting into the factual issues of the case, just laying foundation on whether or not this policeman's radar is even competent testimony or competent evidence to be brought into court. All right? Now, the next thing then is, going on with that, now you've got 18 of these witnesses, and you're going to write out all the questions. You may have 1,000 questions, you may have 20 questions. I don't know how many questions you're going to have. But the more you write down, the more you're going to have, and the more intelligent your presentation is going to be to the jury, to the court, and for the record. All right, now, the jury questions are another extremely important segment of the trial, because this whole thing of jury, which we're going to cover here in lesson 21 and 22, and I'm going to cover it in more detail, and really lay this jury issue out to you in spades, both the grand jury and the petite jury, and how to question jurors and how to disqualify jurors. But so far as preparing your case, you've got to have the jury questions down. Now, I typically use about 80 or 85 questions for a typical juror. It takes about 30 to 45 minutes to go through each juror when I have the questions written out. It takes about 5 minutes to go through the typical juror if you go in there ad lib. When you walk into the courtroom, and I've been in there, I don't even know how many times. I mean, there's a lot of times that I've talked to jurors, and I'm sitting over here. What's your name, sir? Would you please state your name for the record? And Smith. And where did you live, Peggy? Objection. That's in the record, and the file is in front of Mr. Gordon. He's asking these superfluous questions. You have to have something to get started on. If you have them in front of you, what's your name, your address, how many children, where were you educated, are you a native of Idaho? Do you have a driver's license? Have you ever served on a jury before? What kind of a jury and why, and so on, and you go down. We have a list, and with lessons 21, 22, we're going to send that list to you. But what I'm trying to emphasize here in this lesson 20 is that you go in there prepared. And so another thing that you want to make sure that you do is that you have plenty of yellow paper when you walk in. You should have a clean, fresh tablet that's not used at all, and that sits over here. And then here's your prepared text, and it starts off up here with jury voir dire, and then, of course, you've got all your subpoenas out and issued, and all your witnesses are sitting around here in the courtroom, and you're all ready with the witnesses now. And this jury voir dire should take half to one whole day. If you've got 6 jurors, if you're going to select one of these 6-man juries, then it should take you at least one half of a day and possibly all day. Some of our students are skilled enough now that they can voir dire a jury, and it takes an entire day, and we've had them actually run through so many jurors that they run out of a jury panel, and they'll either dismiss because they don't have any more jurors, or if they don't dismiss, then they'll have to run out and scour up 3 or 4 more jurors to bring in. And another thing that it tells the jury, when you're kicking people out, it tells the jury that you're serious about this, and this is a serious case. When you go in there and you ask 3 or 4 questions, and the jury is picked out of the first 6, 8, or 10 candidates, this is just a Mickey Mouse case, and ho-hum, and blah, blah, blah. The seriousness with which you show that jury and that court that any case important enough to prosecute me with is important enough for me to defend sends a message to the prosecutor, sends a message to the judge for the next time. Hey, this Gordon takes a day or 2 days just to pick a 6-man jury. Hey, this is more than we can handle. This guy comes in with 15 to 20 witnesses every time, and it takes 3 or 4 days to try this. Hey, we don't want this guy. Let's see if there's some way that we can dismiss. And I'm not kidding you. Our students tell us time after time, and our engineer sitting over here right now, he's laughing behind the camera over here. He just won his 9th case. He's the fellow that walked in and said, oh, it's 10 now. He's up to 10. And he's sitting over here saying, I object. I don't want this case dismissed. I want to try this case. Sit down and shut up. That's how bad they want to prosecute this guy. All right. Remember, this preparation and this planning, when you walk in there, you're a serious person walking into that court wanting redress of grievance. You're not just walking in there, let's see, what are we doing here today? I don't need any witnesses, and the jury, I don't know how to pick a jury. I mean, every stage of this, you treat just like it was murder 1. You're going through this trial just like you were charged with first-degree murder, and they're going to hang you. I'll tell you, if you were charged with murder, you'd be pretty serious. All right, so here's your jury questions. We have 84 of them prepared, and it doesn't necessarily mean now that when you're voir diring the jury that you're going to ask them all 84 of those questions. Some people will walk in there and have 150 or 200 questions that they want to ask potential jurors. One thing that you want to be careful about is that, when you ask the juror and you're going down your prepared list, this can't be mechanical. It's got to be serious and logical. For instance, what's your name? Sally Smith. Sally, are you married? No. How many children do you have? Yeah. If she's not married, you don't want to embarrass her by asking her how many children she has. If she says, married, do you have any children? Yes. How many? 4. I see. And about how old are they? In the event that somebody objects, wait a minute, I want to know whether or not she's got 4 little kids down here and we're taking her away from her home and she's paying $25 a day in babysitting fees and being compensated $5 a day as a juror, and whether she's going to go in there and give me about 15 minutes of her time because she's in a panic to get home. She can either serve as a juror or she can't. See what you're doing there? So you want to go through your questions logically, intelligently, and coherently, and you just can't do that unless you've got the questions written down and you're prepared for it. And if you don't want to prepare for it, well, then you're really not serious enough to try one of these cases. And if you're not that serious, well, then maybe you ought to just pay the fine and go home. But if you're serious, let me tell you, when you walk in there, as I did, I'm going to tell you this little story. When I was a youngster in school, I was a big, tall, skinny kid, and I probably didn't weigh more than 140 pounds or so, and I couldn't play football. I probably could play basketball, but I was really more interested in work. And anyway, I went to this new school, and we went into the ag department, and there was a pretty good-sized kid in there. I'd say probably weighed 180 or 90 pounds, big, brawny guy. And he'd been to that school all of his life, and here I am, the new kid on the block, and he came over and, hey, what's your name? And I think I told him, my name's George, and he says, hey, good to know you, kerblow. He hit me in the arm, and you know how that stings, a guy hits in the arm? So I just hauled off, and I hit him right in the mouth, knocked him down, and the fight was on, and it lasted about 5 minutes, and he just thrashed me. And, they send you to the principal, and they send you to the dean of boys, and you go through this little rigmarole over here, and they put you on probation and keep you in and do all these things. Next day, he walks over, as soon as we walked into ag shop, and he came right over there, and he said, and he hit me again, and he said, you had enough? And I busted him right in the nose. And I knocked him down again. And he just thrashed me within an inch of my life. And we went through the rigmarole to the dean of boys and back and forth again. But on the 3rd day, he didn't come over and ask me anything. In fact, I don't think we ever talked for the rest of school. And I'll tell you something else. Everybody else in the ag shop never came over and messed with me. Not because they couldn't come over and beat me up, but because everybody that messed with me got a bloody nose. And it doesn't take them long until they figure out, well, we know we can always beat old Gordon in the courtroom in front of the jury. But the problem is, it always takes a lot of blood out of us to do it, every time. And they just don't have the kind of staying power that I have. And that's the kind of staying power that you've got to have. And that's why I always caution my students, if you're ultimately going to sign that fingerprint card anyway, because you're not prepared to spend the rest of your life in prison, then don't raise the issue. Just sign it and give them your prints. If you are going to fill out that W-4 form or W-2 form or that tax form rather than go to jail for contempt of court, then don't go to jail for contempt of court. What you do is just fill it out and shut up. Gather your straw, make your bricks, and don't make waves until such time that you're prepared to make that kind of commitment. When you do that, you're going to find out that your adversaries all of a sudden say, that guy is just more than we want to handle. We know we can beat him up, but the blood that we have to spill doing it just isn't worth our time, effort, and energy. All right, the next item then is